Welcome, everyone. We're going to start because we are going to stay on time. We're going to start on time and we're going to end on time. So I want to welcome everyone. For those of you who don't know me, my name is Bill Silverman. I run the pro bono program here at Proskauer, and it's a real privilege to be hosting day one of this wonderful conference. Please, if you want CLE credit, you must fill out this form that's in the middle of the table, and then just leave it, please, in the middle of the table. If you don't fill it out, you won't get CLE credit. And for those of you who are virtual, I welcome. Thank you for joining us. You will have a CLE form and a code for each panel that you will then return to us. The code is only for the people who are watching this virtually. So before I introduce Jennifer, in Jay Johnson's report on race in the court system, he referred to the family court, among other courts, as a second-class system of justice. And I really think that that kind of says it all. On a report that I worked on for the City Bar Association and the Fund for Modern Courts, we looked at the impact of COVID on the family court. And, you know, we talked about decades of inequities that were laid bare by COVID. During COVID, the court distinguished between essential and non-essential matters. Custody, visitation, and support were generally non-essential. So tell that to the woman you're going to hear about later today, who didn't see her daughter for 4 months because the abuser didn't let her see her daughter. That was a non-essential case. So I think it's important that we're not just preaching to the converted, but that we use this conference not only to learn about the inequities and injustices that are occurring, but that we actually take action, that we actually do something following this conference to try to address these issues. Thank you very much for being here. I'd now like to turn this over to Jennifer Friedman.
Thank you, Bill. And I'm just doing a 1-second tech check. We're good. We're good. Tech, we're good. We're recording. We are recording. Okay. I felt the need to do that. It's a new world. We're in hybrid. Hello to everybody in the room. Hello to everybody online joining us. And thank you, Bill. We are so grateful to you and Proskauer as our general host today. Bill has been joining us for several years now in this roundtable that are the brains behind this operation this morning. And he has been an incredibly valuable and passionate advocate and partner. Thank you, Bill. It is really exciting to be here, and I would like to welcome everyone to Justice for Survivors of Intimate Partner Violence, Transforming an Inequitable Family Law System. What an important mission we have set for ourselves for the 2 days we all have together. Our ambitious agenda is to identify, name, and describe the injustices that we have all experienced in the family law system, and to develop concrete solutions, as Bill has asked us to do. Our 7 panels will include mental health experts, jurists, survivors, advocates, researchers, and practitioners who will come together to identify solutions to what have come to seem to many of us like intractable problems. Then, during the last panel of day 2, we will set an advocacy agenda built on the conclusions of each of these panels, an agenda that we, as a community, can act upon together. I hope you will share my enthusiasm as we embark on these 2 days together. So now that you know where we're going, let's take a moment to ask, how did we get here? To answer that question, I'm going to share my own experience and perspectives by first taking us back to the late 1990s and early 2000s, when I was at that time a recent law graduate. At that time, the domestic violence legal field wasn't even really a field. It was basically a small handful of attorneys at a few nonprofit organizations litigating in family court. I was at Sanctuary for Families, where we had a legal staff of 5. Now we have a legal staff of 90. I know that many of my colleagues from those early days at our sister agencies are still in the movement to this day and joining us at this conference right now. I see you. I see you. Although historically, domestic violence at that time had been ignored by the authorities and minimized by the courts, by this time, our movement was now gaining momentum. There was a growing consensus that the system had to protect DV survivors, and the courts did begin to evolve. In response to the brutal murder of a DV victim and the powerful demand for change, then Chief Judge Judith Kaye spearheaded the integrated domestic violence courts. There was a significant influx in state, city, and federal funds that enabled agencies to increase their staffs and needed services, like, for example, representation in immigration proceedings. Law firms were eager to supplement these services with pro bono efforts, and their contributions rose exponentially. By the time I left Sanctuary in 2008 to join Pace Law School, it seemed that justice for survivors in our courts would only continue to improve. A decade later, when I returned to practice at Sanctuary, I immediately noticed that something had changed. I regularly heard from staff attorneys that we had to be careful that we only file petitions for orders of protection immediately after a violent incident, because judges didn't want to hear about past domestic violence. That's not what the law says. And while it had always been best practices to file OP petitions and custody petitions together, I now heard that we had to be careful that DV not be seen as an opportunity for a leg up in custody proceedings. I heard about cases with serious allegations where judges failed to issue stay-away orders, and cases where the family court judge demanded to know why the victim had not called the police. And then I had an experience that I found truly shocking. I was appearing on a case in which a mother of 2 small children was our client, and the unemployed father had committed a pattern of domestic violence against her. He had attempted suicide in the home while the children were present. Our client had left him, and he was now stalking her. I thought for sure the court would recognize the acute danger my client and the children were in and would reasonably respond to their plight. Supervised visitation had taken place, and the father had tried during the supervision and in front of the supervisor to hand the older child a cell phone that he had purchased for him. Our client expressed well-founded concerns that the father might try to track their whereabouts using the phone. During the court appearance, opposing counsel was outraged and argued vociferously to the referee that our client was alienating the father from the children. How dare she suggest that he might try to track them? The referee turned to my client, raised her voice, and scolded her, warning that if she heard about any more of this alienating behavior, she would transfer custody of the children to the father. With that one phrase, parental alienation, the entire narrative of the case had changed. My client was stunned. The authority figure she had turned to for support and protection was aligned with the abuser, seemingly, and was threatening to give him custody. That was when I realized that we were in a backlash. Following this experience, several colleagues and I began discussing these troubling dynamics, along with the endemic problems we had always known about that were exacerbating them. These include, and I feel like I almost want to say, join me and sing with feeling, because all of us know these endemic family court problems. Profound lack of resources in the family courts. The serious shortage of judges, resulting in huge case dockets. Long delays in case adjudication. Insufficient focus on the seriousness of survivors' cases. The constant cycling of judges in and out of the family courts on 2-year rotations, causing massive case turnover and particularly recently, even mistrials. And the exodus of court-appointed attorneys from the 18 panel due to their low pay rates. And finally, in the wake of Jay Johnson's groundbreaking report, which we've already heard about from Bill and we'll be hearing more about today, we discussed inequity in the New York State court system. We discussed another endemic problem, racism and other bias against survivors and attorneys and other staff, especially for women of color and immigrants and others with intersecting identities. That's a lot of problems. These conversations became even more pressing during the pandemic, when these problems were compounded by the crisis. As we know, the impacts are still being felt. As a next step, we invited additional colleagues into these conversations. We convened the Family Law Roundtable, and we met for 10 two-hour facilitated sessions where we did a deep dive into these thorny and seemingly intractable issues, supported by research by Proskauer. This process crystallized our thinking and led us to convene this conference. So now you know why you're all here. And it looks like we have hit a nerve. We have, and this is shocking to me, over 750 registered attendees here in person today and online. We hope this conference will be the beginning and a continuation, really, for many, many of us here in person and online who have been discussing these issues for a long time, of an overdue conversation, including key stakeholders about what's broken, and we will emerge with an advocacy agenda for how to fix it. So that's our mission. I hope you in the room and online will dig in with us and join us in this incredible brain trust that we have convened in these 2 days. Now, I would like to take a moment to introduce the members of the roundtable who are on the slide in the room and I hope are being seen virtually. This is a brilliant group of passionate advocates and their agencies and names are on the slide. I wanted to bring them up here, but we decided that was a little awkward, so we didn't do that, but I really want to acknowledge them all. And I'd like to especially mention Jennifer Berry, who has volunteered her time to this incredible effort. I'd also like to acknowledge our co-sponsoring agencies, which are all listed on the HOVA site. There are many of them, and it will take me a long time to list them, but you know who you are. A conference like this takes a lot of preparation, and I'd also like to thank all of the subcommittees for each panel who put the panels together, and you can see all of their names in the tab on the HOVA site. During the next 2 days, we are grappling with very intense, personal, and often traumatic topics. And I'm very honored that we have several survivors who will be speaking with us over these 2 days. While it is crucial that we discuss these issues, we also understand that these conversations can be triggering. We urge and invite you to practice self-care. If this means turning off your device, leaving the room, checking out, and maybe checking back in, please do so. If you are feeling triggered, we have resources listed on the tab on HOVA labeled self-care and resources. Regarding CLE, there's a tab on HOVA that clearly explains all the protocols, and Bill already explained them, so I'm not going to take more time with that now. But if you are confused or need any help, please find myself or any of the other hosts, and we can direct you for how to get your CLE. Regarding HOVA, the whole agenda and schedule is on the app. So hopefully you've been navigating around the app and you've gotten a little accustomed. For those joining virtually, we will be offline during lunch, but invite all of you to rejoin for our fantastic lunchtime speaker at 12:25. If you have any technical issues, you can email support@hova.com. and we should hopefully be able to assist you. We hope that you will enjoy the interactivity offered by HOVA, including the many message boards and other ways to connect. We have posted community guidelines on the logistics area of the HOVA site and encourage you to review them. The hosts will be monitoring the message boards and will remove anything in violation of the community guidelines. We also urge you to remain present during the panels by actively listening, and we will not be activating the chat features during that time. We do encourage you to engage with the panelists by submitting questions. You can do this by sending a question to Q&A, that's letter Q ampersand letter A monitor, which will appear as a profile, as like an attendee profile in HOVA. So you just go to that profile and send a DM, and that will send a question to the person who's sitting over there with the laptop, which is going to be me in a minute. And finally, as an additional note, this entire conference is being recorded. For those attending in person tomorrow at Gibson Dunn, please check your email. There is an important form that must be submitted in advance of your arrival, and you just click send. You fill it out and click send. It's very easy, and they have let us know that not many people have submitted their forms, so please do that. Okay, now we're moving on. It is absolutely my pleasure to introduce the Honorable Judy Kluger, who will moderate our keynote panel. While I will not recite all of her many accomplishments, and I also encourage you throughout this entire conference, it's very interactive. If you click on a speaker, their whole bio comes up and you can read their whole bio. But I will provide just a few highlights here. Judge Kluger started her career as a special victims prosecutor in Brooklyn and ultimately rose to become a judge, serving on the bench for 25 years. Later, as chief of policy and planning for the New York State court system, she oversaw the state's 300 problem-solving courts and played an integral role in the creation and implementation of the state's integrated domestic violence courts. She joined Sanctuary for Families in 2014 as our executive director. I am honored to introduce Judge Judy Kluger.
And for being the architect of this conference. Jennifer's full-time job has been conference coordinator for the last 7 months. It's a pleasure to be here with our in-person attendees, as well as a large. There you go. Once again, it's a pleasure to be here with all of you in person, as well as our very large virtual audience that Jennifer mentioned, over 700 participants from around the country. This speaks to the crucial nature of the issues affecting families in the New York State courts, as well as families across the country. Before I begin our keynote conversation with my esteemed friends and colleagues to my left, Judge Betty Weinberg Ellerin and Justice Troy Weber, I'd like to take a moment to thank the law firm of Proskauer Rose and Proskauer partner Bill Silverman for hosting us today, and to Sanctuary's mighty team of Jeannie, Genevieve, and Asil for the invaluable assistance they have given in coordinating the many, many moving parts of the conference. Both Judge Ellerin and Justice Weber have had auspicious careers prior to ascending to the bench, and many groundbreaking accomplishments during their judicial tenures. Their impressive bios are in your materials, and I urge you to read about each of them, pioneers in so many aspects of their work, fierce and fearless advocates for change. It is because of their experience, commitment, and dedication to equity and fairness in our courts that I asked them to join me for this conversation. Judge Weber currently sits on the New York State Court's Appellate Division First Department and is co-chair of the Franklin H. Williams Judicial Commission. This commission was formed in 1998 to educate and advise the court system on issues affecting litigants and employees of color. Judge Weber also served as an advisor to Secretary Jay Johnson, who issued the 2020 report on equal justice in the courts. Judge Ellerin has had a storied judicial career, which includes being appointed the first female presiding justice of the Appellate Division First Department. She is currently senior counsel at the firm of Austin and Bird, and among her many, many activities, she chairs the New York State Committee on Women in the Courts, which produced the 2020 Gender Survey, a follow-up to a 1988 report on gender bias in the courts. So, justices, let's just dive into our conversation. First, I'm going to ask each of you to describe the roles and respective functions of the committees and commissions. And starting with Judge Ellerin, the New York State Committee on Women in the Courts issued a recent report that we'll be discussing today. Can you tell us about the purpose of the committee and your role in that committee?
And how it arose.
Yes, it's history.
But before I do that, I hope I can say a few words about how happy I am to be here, particularly in person. And let me say this, when Judy Kluger invited me, I can't say no. I think she was one of the most tremendous judges we ever had in the areas that she served, and particularly when she was at the family court. The sanctuary lucked out, but the court system suffered a great loss when she, well, I have to say
Okay, now
that.
I'm going to ask you to answer the question.
No, not yet. I'm exercising some judicial privilege. And it's truly a pleasure to be on the panel with Justice Weber. Now, Justice Weber sits on the court where unfortunately I had to retire for age, but I had a unique experience with her. I appeared before her as a practicing lawyer after I retired from the bench, and she was a surrogate of New York County. She was fabulous. That's all I can say. And my only regret is that I'm not sitting on the bench with her, because I know she enriches that bench greatly. Now, let me get to the topic I was brought here.
Now you'll answer the
Right.
question.
And I'm going to answer the question perhaps a little longer than Judge Kluger anticipates.
But I cannot cut her off, you understand?
That's all right, you can. I may overthrow you, but in any event, listen, women have had unequal treatment in our society generally, going back to time immemorial. But it was in the early 1980s that respected academic studies raised the issue about the fact that women were not being treated fairly in our court systems, our systems of justice. And that really was quite a dramatic shock to many of us who loved our court systems, although we recognized that there was great merit to that statement. In any event, there were a group of us in New York. I was then the city administrative judge, and we had an unusual chief judge named Lawrence Cook, a gentleman from Monticello, New York, who was committed to fairness. He promoted women, minorities, men and women to positions of authority within the court system, and he truly lived by a code of fairness. So when we approached him about setting up a committee to study the New York court system to see if it fell within the description of those academic studies, originally he was a little reluctant because he felt that might be, after all, he did not do that here in New York, but he then recognized it was important to do so. And he set up the New York Task Force on Women in the Courts, a very prestigious group. I, of course, had a list of feminists and strong, advocates who I would have suggested as members. No. He put on Wall Street lawyers, bar association leaders, academics, and what have you. Well, let me tell you, and public officials, he was right and I was wrong, because there's nothing like a convert to spread the message. That committee acted for 2 years. They had hearings. They had public hearing, private listening sessions. They truly did an investigation of how women were being treated in the court system. And I will say that they really left no stone unturned. And one of the things they did was they had a survey on various of the issues. And this is what they concluded. Their mission had been to examine the New York State courts to identify gender bias and, if found, to make recommendations for its remediation. Well, after the 2 years of study, this is what they concluded: that gender bias against women litigants, lawyers, and court personnel is a pervasive problem with grave consequences. Women are too often denied equal justice, equal treatment, and equal opportunity. The 300+ page report, and fortunately there's also a summary, really with specificity demonstrates the areas where women were not being treated fairly, including, and they just picked 3 or 4 very significant areas. And one of them was how women litigants were treated. And that, of course, is of particular relevance to today's discussion, and particularly in the area of domestic violence and violence against women generally. Frankly, those sections, I urge you to read some of that report. You can get it online. And I want to introduce the executive director of our committee, Charlotte Watson, who's here today, and she'll be happy to provide you with whatever the sites are. I'm a technological, ignoramus that you can attribute to age. Okay.
It's on HOVA, so you can just click on it and
Okay,
see all the
good.
reports.
Now, in that report, and this sort of made your hair stand up, and was the court's response to violence against women. And throughout that section is an issue that pervades everything in terms of how the courts treat women: the lack of credibility that's given to women. And that was particularly the case in cases of domestic violence. Oh, she's making it up. She's using it because she's got a divorce action, all sorts of things like that. And there's no physical injuries. What kind of domestic violence? I mean, those were the kinds of situations that actually occurred in our courts. Now, one of the recommendations of the task force was the creation of a permanent committee to see whether the recommendations, and there were extensive recommendations in the report for the remediation of these problems, and particularly in the area of domestic violence and violence against women in other contexts as well. But one of the recommendations was to set up a committee to ensure that those recommendations were carried out and fulfilled by the powers that be. And that include court administration, and there were recommendations also directed to bar associations, to legislators, and DAs, and other institutions. Now, when the report was issued, it was issued in 1986, in April of '86. By that time, Judge Cook's term had come to an end, and it was I never learned to type, because in my day, if you wanted to be a lawyer, you didn't learn to type because they'd use you as a secretary instead. And so I couldn't lie. So I said, no, I don't know how to type. So I'm reading my own handwriting here. Okay, in any event, when the report was, handed down to the chief judge, it was to a new chief judge, Sal Wachtler. And he accepted it and indicated that it would be a top priority for him. And he was true to his word. And he established this committee to implement the recommendations. And he appointed then the late Catherine McDonald, who was then the administrative judge of the family court. And let me say, that was an inspired choice. She was wonderful. Not only did she take seriously the recommendations, but she saw something that the committee itself had not seen, or the task force. One committee statewide couldn't do it all. So she set about with staff setting up local gender fairness committees throughout the state, one in every judicial district, and within the city in the various court divisions. And they have been very helpful in terms of doing part of the implementation and in keeping the committee itself advised of what's going on in the various parts of the state. Now, Judge McDonald served for about 15 years, and then she retired and became the chair emeritus. And I took over after that. And we have been working throughout the years to try to implement the various recommendations. And among our other activities has been education. Programs, particularly for judges, for law assistants, for court personnel, sensitizing them to various issues of domestic violence, of how all litigants and others must be treated fairly. And by the way, we take the position that, just lecturing to people doesn't always work. So we tried something a little different. We used to have vignettes at the annual judicial education programs of conduct that would obviously be biased and how a judge should address it. One of the biggest complaints was that judges may not have all, and that was true, been, bigoted or prejudiced, but they allowed that kind of conduct against women to go stopped. And judges have an obligation to control the courtroom. So we have these vignettes, or we used to give these vignettes. Many of them were very amusing, with various, ways that a judge could intercede to stop the adverse conduct. We also recognized a couple of things, and we have a whole list of things that we've done over the course of the years. For example, we pushed for special parts for the DV and IDV parts. We pushed for and were successful in getting part-time and flex time long before that became, popular for usually women court employees, so they could also, maintain part-time work with the courts, but still they had family responsibilities. Unfortunately, as time has gone on, subsequent administrations have not been so sensitive to that particular issue, although I think with the current, situation, it may come into fashion again. Also, we recognized that poor women were in a particularly precarious position. If they had to go to court, let's say there was a housing court, hearing, a poor woman who had children, she couldn't afford a babysitter. What was she going to do with the children? Because when she'd come to the courtroom, frequently the court officers would say, "Oh, you can't go in with the children." So we urged and were successful in obtaining children's waiting rooms in various courts throughout, the state. Unfortunately, the minute there was a financial crisis, those centers Some of them were shut down, some of them, the hours were curtailed, but that's something that we have pushed for, continue to push for. And that is because we recognize that poor litigants require some special attention. Then we have so many people in our court system who do not speak or understand English. And those frequently are the victims of domestic violence. Well, unfortunately, our interpreting services are not so terrific from way back. And that was an issue that was pushed by our committee, and I want to give credit to Fern Scher, our vice chair. She undertook that mission, and she got the court system to set up an advisory committee, and with various improvements in getting more and more qualified interpreters. We were always concerned that some of the women who appeared may have come from societies where domestic violence, was not necessarily viewed as something you went public on. And some of the interpreters, we felt, were communicating that message to a witness who came in on a case like that. And so we really have been very active and concerned about that. In any event, we had from 1986 on to about 2018 or 19, we continued with all of our activities. But in more recent, and the one thing that we had pushed was there aren't enough women judges. My God, when we started out, there were a handful of judges. And I must say that women judges, I must say that was one area where progress really was terrific. We got enormous numbers of women judges and many women judges in positions of authority. And we've had 2 women chief judges. We've had the Court of Appeals has had a majority of women. The Appellate Division, where I was the only woman for 11 years, today is a majority of women. And there are women administrative judges. There we've been successful. But the question, what we were getting back though from our local committees was that there was a lot of, there were a lot of problems that women in the system as lawyers, litigants, and employees were suffering. So we decided, it's time for another survey. And that's what we did. Of course, we did it with technology. We surveyed all the lawyers in New York who had an email address. We got over 5,000 responses. And that was a remarkable number, equal men and women. And it was interesting that many of the responses showed the difference in views of the men and women respondents. The net would be,
Judge Ellerin, I'm going to just.
I'm going to finish. This is my last sentence. My last sentence.
Okay.
We've made a lot of progress, but we still have a long way to go. Okay?
Yes, absolutely. And part of the reason that committee has made the progress it has is because of the energy and ferocity of Judge Ellerin. I'm going to turn to Judge Weber now. Judge Weber, you're co-chair of the Frank and H. Williams Commission. Could you tell us about the commission, its history, its role, and also about what the Jay Johnson report has told us about equity in the courts now?
Yes, definitely. Thank you, Judge Kluger. I think Judge Kluger was one of my first supervising judges. I think when I was in criminal court way back when I first became a judge. Judge Ellerin, we all defer to her, and you really have to read her bio. She is a pioneer, and please, she is wonderful, and she is an inspiration to all of us. Her picture, her portrait, hangs outside my chambers. So I actually see her face every morning. And every time I leave my chambers, I see her face. Every time I go back, I see her face. and it is scary at times. But she is great. So please. So yes, I want to be clear. The Franklin H. Williams Commission, I don't know if any of you are familiar with the commission. We are an independent, permanent commission dedicated to eradicating systemic racism in the court system. And what we do is we take affirmative steps to eliminate barriers to racial and ethnic fairness in the courts, all courts. So our mandate is a greater one. We look at all of the courts, there are various courts in the New York State court system, including family court. We look at the judicial as well as non-judicial personnel. We look to determine whether there is diversity, whether there are issues in terms of jurors, for example, litigants, individuals who come to the various courthouses, to stakeholders. We also are involved in a pipeline to the bench, to law school. We put on programs and speak to law students. We attempt to increase that pipeline. Judge Ellerin mentioned the number of female judges. We have fewer female judges now. We also have fewer judges of color, male and female, right? Which is an issue. So, we have to increase those numbers in general. So we look at the court system as a whole, and many of the issues that Judge Ellerin mentioned in terms of interpreters, in terms of, the diversity of the judiciary, et cetera. These are all things that the Williams Commission looks to. And so when I say this, I always want to be clear, we are independent. And people say, well, you're funded by the court system. Yeah, we are funded by the court system, but we're still independent. And so we still will make recommendations. And when we see things that there's an issue, we present it to the powers that be. And that would be the chief judge. And thus far, the chief judges, Judge DeFiore, Judge Kaye, Judge Littman, have all worked with us in terms of trying to deal with these issues. There's some of the supervising judges, administrative judges, some of them we have issues with, especially upstate, but we're being recorded, right?
Yes.
And
they're upstaters.
And they're upstaters,
yeah.
so we have to be careful. But, for the most part, individuals will work with us. So it was mentioned that we came in existence actually in 1991. And that at that time, in 1988, Franklin Williams, who was an ambassador and also a civil rights activist, he was charged by Judge Wackler to render a report, and he rendered the report on minorities. I got to tell you, I don't like the word minorities, so I don't use that term. But anyhow, he rendered a report on, okay. And it's interesting because we talk about Jay Johnson's report, and I have the ultimate respect for Secretary Johnson in all that he's done. However, a lot of the things that he found in his report, which he rendered in, 2018, 2019, was a mirror image of what Franklin Williams found in his report in 1991. And I always kid Secretary Johnson. I'm like, you could have just taken the page from Franklin Williams' report and put it on your report and say, here's the report. Because unfortunately, there were so many of the same issues that he found. And so, as I said, what we do is we are tasked with eradicating systemic racism, et cetera. We have proposed, and OCA, the Office of Court Administration, has been receptive. So we made, based upon Secretary Johnson's report, and also based upon our own hearings and conversations with stakeholders, et cetera, we proposed, and it was accepted, mandatory implicit bias training for all individuals within the court system, judges as well as other court personnel. And we wanted everything to come from the top, right? So who took part in the first mandatory implicit bias training? Judge DeFiore, Judge Marks, and the supervising judges and administrative judges. So that was important. Also, we wanted to make sure that there was access, full access to those individuals who had some type of issue in terms of language. So language access. Also, and I'll get into that, we also have rendered or in the process of actually distributing a report that we did recently. I think you guys remember back in June, I believe that was 2019, COVID kind of fuzzed up my brain in terms of dates. I don't know where I am. I think it was June 2019. There was an incident in family court where the clerk made reference to a child and called him the N-word, and there was court on a hot mic. So based upon that, we, Williams Commission, what we did is we brought folks in and we spoke to the administrators of family court. We spoke to other stakeholders. We probably spoke to some of the organizations that you're a part of. We spoke to attorneys. We spoke to others concerning what was going on in family court. And so we, believe it or not, we one of the recommendations is that there be this level of respect from the judges. Now, why would you think you'd have to have a bill of rights or whatever saying that judges and court personnel have to be respectful to the litigants? It was crazy, but it was something that we thought that it was important in terms of the way in which judges and other court personnel referred to the litigants, referred to the parents and the guardians of the litigants. And so these are things that we got into in terms in our report and how to refer to people, that you should be respectful. The issue in terms of bias, the issue in terms of in Jay Johnson's report, and I think we all know this, and one of the things that the Williams Commission has focused on is that those courts which are used by primarily individuals of color, those courts are the ones that receive the least resources, right? So we were going to look at criminal court first because my heart is in criminal court. That's where I kind of grew up, in criminal court. We were going to look at criminal court, then we were going to look at housing court, which is a big issue, which is worse. And then we were going to look at family court. But because of this incident, we looked to family court first. And so one of the things that we found is a total lack of resources given to family court. And I'm talking in terms of the building. And we have photos, and I'm sure you guys have seen this when you enter these courthouses, in terms of the mold, in terms of the leaks. Bronx Family Court, unbelievable, right? In terms of the leaks. It's going to rain this evening, right? So you go to Bronx Family Court tomorrow, there'll probably be puddles and buckets, right? Catching the water. And so these are types of things. How do you feel as a litigant and as an individual walking into that courthouse, right? How do you feel? How does that make you feel? Does that not make you feel that they don't care about me? Obviously, they don't take this seriously. If things, if you have mold, if you have leaks, et cetera. So these are some of the things that we look to and some of the things that we are attempting to remedy. And so I'll get into that a little later.
So a little bit about judicial assignments, and we unfortunately have to wrap up very soon. But when you talk about under-resourced and just a neglected court, what do you have to say about judicial assignments relevant to the family court?
So very quickly, we met, and this was one of the issues we looked to also in terms of family court judges. So one of the recommendations that we made was that they increase the number of family court judges. And I know they have increased it. I think there are an additional 4 family court judges, I believe. Not enough. We, the Williams Commission, proposed 15 new family court judges. And so we'll see what happens with that. We've spoken to the legislators, et cetera, and also with the mayor's office in terms of increasing the numbers. They say they're with us. I want to just, as an aside, another thing was 18B compensation, which you all know is a really important issue. We spoke to the governor's office. We spoke to the governor's council. They said they were on board, no problems, everything was fine. We spoke to the legislators. They said, oh, we're on board. And well, I don't know what happened. But that's something that we're also pushing for. And also increasing the number of judges is something that's important also. And also trying to cut down on the cycling in, cycling out. So we actually had a meeting a couple of weeks ago, and Ms. Friedman was mentioning that some of the judges were declaring mistrials, right? If there was going to be another assignment, that they would declare a mistrial. So I could not believe that this was occurring. So of course I called Judge Kaplan and Judge Marks and Judge Jolly. They said, really, you're declaring a mistrial? Now, remember, I sit on the appellate division, right? So for me, this is a no-no, right? Can't do this. So I called them and I said, it's come to our attention that judges are declaring mistrials, and you can't do that. Why? Is this your policy? They told me that this was not the policy. They told me that this should not occur. They told me that if it does occur, that they want to know if it is occurring, because they stated that they have specifically told the judges not to declare a mistrial. Either take the case with you where you're being reassigned, or return to that location to continue the trial. So what I'm saying to you is, if this does occur, and if a judge tells you that they're cycling, she's going to write this down. The judge tells you that they are going to declare a mistrial in a case, please let me know. You have my email. Email me, and then I will send it on to Judge Kaplan, Judge Jolly, and Judge Marks, because Judge Kaplan stated that she wanted to know. Okay, so perhaps this is something, a positive, something that has come out of this conference, which will be positive.
I would like to
Absolutely.
say that it seemed that your call had impact.
I was shocked. I was like, really? Ms. Friedman, you're kidding, right? And then immediately got on the phone. I was like, really? This is going on?
Yes. Could I make this point? Family court judges are appointed by the mayor. And what's important is to make sure that you have people that you approve as judges who really are committed to the family court. Unfortunately, many of the candidates that they send look upon that as a stepping stone elsewhere. And that's important, to put pressure on the mayor's committee to make sure that they get people who are deeply committed to the family court and the litigants in that court.
And when they get to family court, another proposal we have is that when they get to family court, that there be special training. I mean, we do have the Judicial Institute, which has training for judges. I've never sat in family court, but I believe that if you're going to sit in family court, there are certain nuances, right? I as a judge, I could sit there, right? Because this was what I do, and I would learn it, right? However, there are training, and I think there's additional training for family court judges, and this is something that we have proposed, is that there be additional training specifically for family court judges and family court personnel, because again, we don't want to put it all on the judges. It's personnel as well who have to learn, because they actually are the first individuals who are going to be meeting with the litigants, et cetera.
So first, a commercial break for the attorneys participating in the program remotely. Please note that the CLE code is FR4E3L. FR4E3L. This code must be included on your CLE form to submit for credit. So I think we're on to questions now.
We are, however, using my executive privilege, I'm going to say, I see the questions and I know your questions. And I'm going to say, why don't you continue?
Okay,
your questions?
Great. Let's talk a little bit about intersectionality. This conference is focusing on bias in the courts in general, and obviously the experience of survivors of gender-based violence. And they come to our courts with many intersectional identities: women, women of color, immigrants, LGBTQ, gender non-binary. How do your findings of your reports impact litigants in these categories? Do you want to start, Judge Weber?
Well, as I said, ours is a greater mandate. So we're looking to things as to teaching, well, first anti-bias, right? Anti-bias training. Also, how to refer to litigants. When a litigant says that they want to be referred to as they, there should not be an issue. That should be the end of the conversation. And believe it or not, we've had some instances where individuals have stated, I want to be referred to as they, or what have you, and the court personnel has, refused to do so, or the judge has refused to do so. So that's, basic, really basic. But again, we look to the community and the court system as a whole. And so we have to make these initiatives, and the understanding has to be statewide. And this goes to training. It really and truly goes to training. Individuals have to be told in the court system, they have to be told what, what is expected of them. We're actually going to post a Bill of Rights in family court as well as in the other courts in terms of you as a litigant, you as a stakeholder, what is expected of you, and also what you should expect. We also want to increase the use of the virtual system as much as possible, so individuals wouldn't necessarily be affected by this as much. And we also try to put in kiosks in the courthouses as well.
Judge Ellerin, I don't think we got a chance to talk about the findings of the 5,000 person survey many years after the original report and survey.
The worst finding from my perspective was the lack of credibility given to women as lawyers, litigants, and witnesses. That's astounding to me. And what was even more astounding was that while the greater percentage of those who did not give credibility to this group were male judges, female judges in great number were also guilty of that. That is to me unbelievable, but that of course impacts tremendously in the area of domestic violence. The women in domestic violence, whatever the backgrounds, really come in having to prove, sort of double prove their case because they are women. And that is, to me, intolerable. And that's an area that our committee is now focusing on and going to try to, take some action on. What we have found in the current committee is there have been improvements in terms of how the authorities, police authorities, respond to requests for order of protection. While they still push them to the family court, they still don't discourage orders of protection. And once a woman does come to criminal court, they are treated okay in that regard. They're not sent back to family court. That's an improvement. Let's see, there was another area on that. Judges have improved tremendously. And I must give, unfortunately, the Commission on Judicial Conduct a little credit. Therapeutically, judges don't want to get in trouble. And so they understand that they have to behave very well to all litigants. Unfortunately, many of them do not stop lawyers from behaving poorly. And that has been a big problem. Lawyers are the worst offenders in terms of, of behaving badly to women at every level.
We're okay on time, Jennifer?
I feel terrible. I took so much time.
No, we have plenty of time. And
no, we have time now?
we have a little time.
A little time. Okay.
Well, maybe let's wrap it up with kind of one recommendation from each of you, and I'll actually point it towards court reform, restructuring. That's been a topic for probably the last 50 years. The court system in New York State is Byzantine in so many ways, and many tiers, many doors that litigants have to navigate. So in addition to court reform, which seems to have been stymied, what else can we as a group do in terms of our recommendations to move forward, both in light of the findings of your committee and commission, and really your own thoughts and experience? So Judge Ellerin.
Oh, well, one thing is that the people who come into the family court have to have lawyers. And recent legislation, I believe, is going to be helpful in that regard. But many lawyers don't want to take those cases because they're non-pay cases. So the 18B scale has to be changed. That was my signature issue when I was the PJ in the year 1999. And the increase has been minuscule. And that's outrageous. People who come into the family court are entitled to the best representation possible. When they get the institutional lawyers, for the most part, they're well represented. But there are not enough of those, and they are entitled to legal representation. And again, I go back to, you want to have judges who want to be in the family court, who want to deal with those issues. And there's got to be some way of psychologically implanting in judges what a wonderful, not so much experience, but what a wonderful service they are performing to the litigants and to the community by serving in that court. I think it's the toughest court that you can serve in, but it also is doing God's work, in my opinion. And let me go back to credibility. We've got to find a way to change the minds of people, particularly in the area of domestic violence.
Thank you, Betty. Judge Weber.
So in terms of court restructuring, or what, I really have no opinion that I could share with this body. 18B compensation is something that we have to work on. We all have to work on it to increase the amount that the 18B attorneys are receiving. As you probably know, the system is such that you have a limited number of family court judges by statute. That is why one of the solutions, we believe, is to increase that number. You have civil court judges. So judges are elected to the civil court, right? And then they are assigned to the family court. In order for them to move up to Supreme Court, where everybody wants to be, right, for the most part, they have to return to the district or wherever they came from so that they can now campaign and be visible so that they go to Supreme Court. So it's built in that they cannot stay in family court, even if they wanted to stay in family court for the purposes of their career, and also for political purposes, because they would create a logjam if they don't, move up to Supreme Court. They can't stay in family court, right? They have to return to civil court so that they can start to move up to Supreme Court, right? So that's one of the issues. You have to make it so that you have family court judges who are assigned to the family court. That is their assignment. And then perhaps they can move up in family court in terms of other positions within family court. And because of this cycling in, cycling out history, I guess, family court is like a second-class citizen because nobody wants to be there because they know that, that nothing's gonna, it's not gonna help them in any way to be there. So we have to, and also, I don't know if you guys know this, but way back when, it was a punishment to be sent to family court. If you judge, you screw up, you're going to family court. It was like, judge, you screw up, you're going to family court in the Bronx because you really screwed up. That is the ultimate punishment was you're going to family court in the Bronx. And I'm a Bronx person. I love the Bronx. So I always took offense to when someone said that. You're going to be punished. You're going to family court in the Bronx. Okay. So that was the mentality. And that mentality continues. So you have to change that. And you have to make family court more attractive. Now, I don't know how you do that. We've been speaking about this to commission. We've been speaking to stakeholders about this. I don't know how you make it more attractive. I do believe that there's a core group of individuals who want to be family court judges, and you have to tap into them. Maybe many of you at some point, would want to go onto the bench and become family court judges, Ms. Friedman, right? And so you have to tap into that because you need those individuals who have, a love of family law and who would then want to send to the bench. So maybe we do more things in terms of, the commission does how to become a judge. Maybe we should do a program, I'm thinking, how to become a family court judge, right? So that we can get individuals who want to go be on the family court bench. But it cannot any longer be seen as either a stepping stone or, a 2-year commitment and then you go back to civil court, nor can it be seen as a punishment. It has to be seen as something that you want to, do and that you have a commitment to.
Well, you have to elevate the status
Yes.
of family court judges. Maybe bar associations ought to give special awards to family court judges. You never see that they're the ones who get the judge of the year, or very rarely. Now that's wrong. They deserve it perhaps more than anyone. Now, allegedly, family court and Supreme Court are on a par, right?
Yes,
Salary-wise.
salary-wise,
Yes,
but yeah.
salary-wise, but not status-wise.
Right.
And we live in a world where status counts. But again, I say, pick out people who want to be family court judges. I bet there are many people in this room who, if given the opportunity, would be, and they would be very happy to be there long term. But the court itself also has to be given some stature and status within the administrative structure.
But then if you have individuals who actually want to be there, they will take pride in the court, right?
That
And
is
then they
true.
will want to implement changes. And I must say, Judge Dolly, she loves family court, and she's an excellent administrator. Judge Mendelson, who I believe you will be hearing from tomorrow, she is a former family court judge, loves family court.
Yeah.
So there are, judges in the system and judges in family court. Let's not deride all of the family court judges. There are many family court judges who really and truly love their jobs and are
That's right.
doing a great
I
job.
understand, but
Yeah.
what I'm saying is we need more.
need
of
more,
them,
right.
And
Yes.
we need to give them stature within the profession generally.
Yeah, yes.
And
I mean,
I will say that the key is to the legislature to allocate more family court
Without
judges.
Yes,
question.
yes.
Because in New York
Without
City,
question.
outside of New York City, it's elected positions, but New York City, Judge Ellerin and I served,
On the
she,
mayor's committee.
on the Mayor's Advisory Committee on the Judiciary, which I still serve. And the people who come and want to be family court judges are terrific. They're
Right.
committed. They've been litigators. 1 minute, I'm going to end with this commercial that it is a process that is, I think, fair, based on merit. And those of you who are interested, take a look into the criteria for the Mayor's Committee on the Judiciary for family court judges. I want to thank this great panel and both for participating today, but even more for being who they are and spearheading the work that they're doing, which is so critical to a fair and equitable court system. So thank you.
Thank you.